Well, we do not challenge.
I know what you don't challenge. You're missing the point.
Whoa!
Well, then let me point the court, if I could, to 7511B. We can have a government that benefits from expertise without being ruled by experts.
No, we can have, but I'm asking you about Congress's choice, Congress's decision that in these particular areas we would like to have independence.
Yeah. But let me make one other point about the real-world danger that is imminent right now that we know will happen.
What?
And that is that if petitioners get their way, everything is on the chopping block. And we're not just talking about the FTC.
Yes.
Opposing counsel.
General Sauer, could you give us one example of a permissible restriction on authority to remove a principal officer?
There isn't any.
We don't believe there are permissible restrictions on principal officers of the United States who exercise the executive power. Now, there may be separate issues relating to particular historical pedigrees.
In this case, in a multi-body agency such as the FTC, is there any permissible restriction?
No, this court in Trump against the United States held that the president's power to remove officers wielding the executive power is conclusive and preclusive.
How far do you go with that? Yeah. Can it be arbitrary, completely arbitrary?
It is conclusive and preclusive, so any review of arguably bad reasons for the president to remove an executive officer would be subject to the political process. It would not be subject to judicial review.
Impeach the
and
president
not
if you're
subject
mad.
to statutes regulating that.
I think there are a lot of agencies in the federal government where it's hard to parse whether it's an executive function they're engaged in or a legislative function. We obviously have the Perlmutter case they're holding where dealing with the Library of Congress, which half of it's a library, half of it's things like the copyright. What are we supposed to do with that, if you're correct?
Well, Mr. Chief Justice, in Free Enterprise Fund, this court, I think, very aptly stated that the vast and varied nature of the federal government is a reason not to make general pronouncements on issues that haven't been briefed and argued. There are certainly situations where there are tough line-drawing problems. You raised the Perlmutter case as one that may raise arguments of that nature, but by and large, this sort of insight that goes from Morrison to FCC against Arlington and to seal of law recognizes that these multi-member agencies that are exercising what this court has repeatedly recognized as quintessential executive powers like the FTC, rulemaking, adjudication, investigation, litigation seeking civil enforcement powers, civil enforcement remedies, and so forth, those are not close cases.
Yeah, I mean, I appreciate your point about not deciding cases that aren't before us, and I meant the Perlmutter case as an example, but I'm not sure you answered the question. Is this a severance issue? So the agency is okay so long as, half of it survives in one branch and half in the other, and if so, who gets to decide that?
For the vast majority of these agencies, I think seal of law pointed out there's maybe about 24 executive agencies that are multi-member structure and have removal authority. I think the logic of this court adopted it for severability in Free Enterprise Fund and seal of law, and Collins indicates that in the vast majority of cases there would be an excision just of the removal authority. Now, if there are agencies that kind of straddle the line between legislative and executive, that might present harder severability conferences.
Yeah, there's a difference, I suppose, between Humphreys and Weiner, right, in terms of whether you overrule one or overrule the other, in terms of the consequences with respect to modern agencies. The Moore Commission in Weiner, if you think that that's more like something like the Court of Appeals or the Armed Forces or the Tax Court or all those others, strikes me that Humphreys may be the issue, and that doesn't mean that Weiner falls with it or that the other agencies fall with it as well.
We have a footnote about this in our brief, footnote 1, and we invite the court to overrule Weiner as well. Part of Weiner we think has been overruled by Braidwood, which is Weiner, interpreted, found a removal restriction that was not in the plain text of the statute, and that contradicts case law from Shurtleff until Braidwood. The other aspect of Weiner that we think is destructive is the phrase, the philosophy of Humphrey's executor. That philosophy of Humphrey's executor seems to have a very firm hold on Congress and a firm hold on the lower courts, and that's why there's been a proliferation of litigation.
Well, there's one thing about philosophy, and there's another thing about holdings. Certainly the holdings of Humphrey's executor doesn't necessarily support Weiner to its fullest extent.
We agree with that.
General Sauer, can I ask you about the Federal Reserve? The other side says that your position would undermine the independence of the Federal Reserve, and they have concerns about that.
Going
to
trickle
share
over
those
to all of them.
concerns. So how would you distinguish the Federal Reserve from agencies such as the Federal Trade Commission?
We don't.
We recognize and acknowledge what this court said in the Wilcox-Harris stay opinion, which is that the Federal Reserve is a quasi-private, uniquely structured entity that follows a distinct historical tradition of the first and second banks of the United States. There's two adjectives there, adjective and an adverb, unique and distinct. The Federal Reserve has been described as sui generis. Any issues of removal restrictions as a member of the Federal Reserve would raise their own set of unique, distinct issues, as this court said in Wilcox-Harris.
John.
We have not challenged those, either in this case or any other case, and so it's not before the court.
But I think the question is if you take your logic at face value, it seems to include a great many things.
What?
If I were to say, your fundamental proposition position in your briefs is that the vesting clause, how many times do you say in your brief, gives the executive power all of it to the president?
The law says.
And if you believe that, the fact that you can say, well, this has a history and that has a tradition, doesn't much go to the rationale that you are asking this court to accept.
Yes, it does.
So once you're down this road, it's a little bit hard to see how you stop. And I think that that's one question. I mean, there's another question about whether you should start at all.
We're not going to stop.
But one question
all
is,
agencies.
if you accept that proposition, which is the fundamental proposition of your brief, it does not seem as though there's a stopping point.
Oh, that's
I think it's the proposition of our brief, but those are obviously quotes from these courts' opinions. So it isn't that we have gone down this road. I think the court has been down this road. The country has been down this road since the decision of 1789. Again, Ex parte Hennon describes this as settled beyond doubt. Again, Parsons, which anticipates all the analysis of Myers, says the very same thing. This is beyond question that there's this removal power. And keep in mind, that's 1897. It's well after the bitter interbranch disputes about the Tenure of Office Act. It's after Congress started engaging in this proliferation of restrictions on the removal of inferior officers.
Well, let me ask you how you would justify, and how you would justify consistent with the proposition that all executive power is vested in the president. Let's start with Article I courts. How would you justify keeping those courts?
Well, those courts, determination would have to be made on a court-by-court basis, so to speak, as to whether or not they're engaging in the executive power. There may be tough line-drawing questions there.
I mean, I thought that one of the things that we've said, again, in many, many cases, is that even though they're engaging in adjudicative functions, they have to be executive by their nature.
There's a dispute about this, I think, basically lurking beneath the surface in the discussions in Ortiz. If they are indeed exercising executive functions, then this logic would apply.
Is it a possibility, let's say you have an agency that is, I don't know, pick a number, 85% is judicial, some of the judicial entities that have been talked about in the briefs, and a smaller percentage is some executive function that they do, whether it's issuing rules or whatever. Is there a principle that you would sever out the smaller little tail on the dog and allow the judicial functions to go on?
Quite possibly. That would be a unique severability question that would be distinct from the merits. So if there was an agency that kind of straddles the line between two branches, and that may raise a different severability to that question. But for the mine run of these multi-member executive agencies, they're clearly exercising executive power. They're doing stuff that the NLRB does, that the MSPB does.
So how about those two? So you are here saying the NLRB goes down, the MSPB goes down, notwithstanding that they do all their work, or almost all their work, in judicial-type proceedings.
I wouldn't say goes down. I would say they were restored to democratic accountability and constitutional structure. But we have contended on
the current versions of those agencies goes down.
They're beautiful
agencies. We have challenged those in
agencies.
this court, NLRB, MSPB, and there are others. This court in Sailor Law. I mean, there's various lists out there.
How about inferior officers?
We haven't challenged any restrictions on inferior officers.
Why wouldn't that also have to go?
That would certainly, restrictions on inferior officers of the United States would be problematic because, of course, Myers is involved in inferior officer.
Right.
The logic of Myers extends to inferior officers.
And obviously, there are all kinds of inferior officers wielding executive power all over the place, yeah?
There are many.
So it seems as though executive officers. How about employees?
Again, we haven't challenged the restrictions on
I know you haven't challenged it. It's really, the question is, where does this lead? What does it take you to, given what your primary rationale is?
Firings.
Employees are wielding executive power all over the place. And yet we've had civil service laws that give them substantial protection from removal for over a century.
Yeah, it's true. Can't fire government
How about
people.
those?
Well, we do not challenge.
I know what you don't challenge. You're missing the point.
Whoa!
Well, then let me point the court, if I could, to 7511B of the civil service laws, the CSRA that we cite in our brief. That is a series of exceptions in it that provides no judicial relief at all to classes of employees, they're called. Now, some of those employees are clearly officers, some aren't. But, for example, presidentially appointed officers, Senate-confirmed officials, those who exercise substantial policymaking or have confidential responsibilities, and, members of the CIA, for employees of the CIA and the Foreign Service. So there's already been the political branches have in many ways already addressed issues with employees. Now, this court obviously dealt with the employee issue in Lucia, and there was a dispute about that, various host lines between employee and inferior officer.
Well, could I ask you
the court can decide those.
Could I ask you
I think
the same question, or maybe just a very similar question in a different way? You've been asked about a number of different agencies. A few of them are likely to come before us in the near future because of actions that the president has taken. Others, as you point out, have not been featured in litigation of which I'm aware up to this point. So suppose Suppose we were to decide this case in your favor without reaching some of the agencies that have been mentioned, like the tax court and the claims court and the Court of Appeals for the Armed Forces, to name the three. Suppose we were to decide the case in your favor, but we did not want to address those other agencies. On what ground, one way or the other, to express a view that would affect those agencies either, as I said, one way or the other? On
How
what,
can we limit
what
this?
would you propose that we say so as to reserve
So we don't gut the whole government.
decision on those agencies that may not come before us in the near future
Well, we want
or
them
perhaps
gutted
at any
too.
time in the future?
Judge Alito?
I think use the language that the court used in Free Enterprise Fund when it said we do not decide the status of lesser functionaries. It pointed out that the dissent in that case and itself pointed out that the federal bureaucracy is vast. And it said we don't want to, given the size and variety of the federal government, that discourages general pronouncements on matters that are not briefed and argued. Now, as to, for example, non-Article 3 courts, I'm not even aware of litigation about those removal restrictions for any of those.
But I really don't understand why the
We know you
agencies
don't.
aren't
We
answering
know.
to Congress. Congress established them and can eliminate them. Congress funds them and can stop. So to the extent that
Then pass
we're
a
concerned
statute,
that
pass
there's
some
some
legislation.
sort of entity that is out of control and has no control, I guess I don't understand that
We
argument.
know you don't.
We would say the constitutional actor on the hypothetical who is controlling these agencies is Congress, and that is a huge separation of powers
No,
problem.
I understand. I'm
No,
just
you
talking about it as a
don't. No, you don't.
practical matter. Part of your argument seemed to revolve around this notion that there's some kind of thing happening with the independent agency, that the reason why the president needs to control it is because they don't answer to anybody.
They don't.
And what I guess I don't understand is why they don't answer to Congress, which establishes the law that they are bound to follow
Congress
and
doesn't execute the law.
determines whether these agencies exist, funds these agencies. All of those things, it would seem to me, would be methods or mechanisms of control.
The Constitution requires clear lines of political accountability. So if
gosh,
Congress
yeah.
is sort of informally actually
talking to like a
controlling
12-year-old.
these agencies through like
He's not
oversight.
right.
Not
hearings.
informally, we have a statute. But let me ask you another question.
Next question.
I guess I have a very different view of the dangers and real-world consequences of your position than what you explored with Justice Kavanaugh.
Everyone's
My
gonna die.
understanding
Yeah.
was that independent agencies exist because Congress has decided that some issues, some matters, some areas should be handled in this way by nonpartisan experts.
No.
That Congress
Ridiculous.
is saying that expertise matters with respect
That's
to aspects
Congress's
of the
job.
economy
They're supposed to
and
be the
transportation
experts.
and the various independent agencies that we have. So having a president come in and fire all the scientists and the doctors and the economists and the PhDs and replacing them
economists, PhDs.
with loyalists and people who don't know anything is
No,
actually not in the
Congress
best
should make those
interest
decisions.
of the citizens of the United States. This is what I think Congress's policy decision is when it says that these certain agencies
Well, it's
were not
unconstitutional.
going
That's
to
their
make
job. They can't delegate
directly
that away.
accountable to the president. So I think there's a pretty significant danger that Congress has actually identified and cares about when it determines that these issues should not be in presidential control. So can you speak to me about the danger of allowing in these various areas the president to actually control
Unconstitutional
the
bureaucracy is
Transportation
much
Board
more of a
and
danger
potentially the
than
Federal
that.
Reserve and all these
the
other
alternative.
independent agencies?
I think the court said it well in Free Enterprise Fund when it said that we can have a government that functions without rule by functionaries. We can have a government that benefits from expertise without being ruled by
No,
experts.
we can have, but I'm asking you about Congress's choice, Congress's decision that in
It's
these particular
unconstitutional.
areas we would like to have independence.
Yeah,
we
they can
don't
pass
want
an
the president
amendment if they wanna
controlling.
create new
I guess
bodies.
what I don't understand from your overarching argument is why that determination of Congress, which makes perfect sense given its duty to protect the people of the United States, why that is subjugated
They should just
to
pass
a
the laws then.
concern
They don't
about
need
the
to delegate
president
it out.
not being able to control everything. I mean, I appreciate there's a conflict between the two, but one would think under our constitutional design, given the history of the monarchy
That you know
and
nothing
the
about, that you don't
concerns that the
understand.
framers had about a president controlling everything, that in the clash between those two, Congress's view that we should be able to have independence with respect to certain issues should take precedence.
Where is that in the
The
Constitution?
constitutional design sets
Thank
up
you.
3 branches of government.
you.
It
Like talking
forbids
like a
Congress from
12-year-old.
controlling what the executive branch does, and it also forbids Congress from shaving away the president's control.
And what I'm
into the
positing is
executive
that
branch.
Congress's decision here is not shaving away the president's control.
Yes, it
Like,
is.
you cast it as that, and I appreciate that. But instead, what Congress is doing is saying we'd like to have independence.
Okay, they go
Nonpartisan
pass the
experts
an amendment, create a new body.
Working on certain issues for the good of the American people.
That's Congress.
And I understand that the president would rather control them,
but
it's not really his decision in the overall scheme of things.
He doesn't control Congress.
Why am I wrong about that?
They're their
the
body.
constitutional design.
It is the president's decision as to how the government is structured and who should be doing what.
No, that is largely Congress's decision with certain exceptions. Congress cannot violate the separation of powers and threaten all of our liberties in the way that it structures the government, and it has done so here.
One last
But
question.
I really want them to. Too
I
bad.
appreciate the effort to try to make this not seem as big a deal as it might be by focusing only on the FTC and saying this is really just about what happens and we'll cross the bridge of the other agencies when we get to it. But can you just give us a sense, because I'm sure you must know this, of what other agencies there are that have the kind of removal protections that are at issue here? There's some,
Get ready.
what, 24?
That's what seal of law said. That's probably a good accounting.
24.
And obviously we have challenged 4 of them in this court, and we're challenging a handful of others.
But you could challenge the National Labor Relations Board, the Nuclear Regulatory Commission, the Commission on Civil Rights, potentially the Sentencing Commission, the Occupational Safety and Health Review Commission, the Consumer Product Safety Commission. All of these have that kind of structure.
I don't know if all of those are on the list. Certainly some of them are.
They will be.
And some of them, and many of these agencies we are litigating, including in this court.
Thank you.
That's right.
Thank you, counsel.
Nice.
The president's constitutional duty to execute the law does not give him the power to violate that law with impunity. But petitioners claim that the president was free to fire Commissioner Slaughter without cause in violation of the FTC Act as authoritatively construed by this court. And, they urge, even if that firing was illegal, there is nothing that any court anywhere at any time could do to remedy that violation. The district court correctly rejected both arguments, and its judgment should be affirmed. On the merits, multi-member commissions with members enjoying some kind of removal protection have been part of our story since 1790. So, if petitioners are right, all 3 branches of government have been wrong from the start. Congress and prior presidents have been wrong to jointly create early founding era commissions and more than 24 traditional independent agencies since 1887.
Commissions,
and
committees,
this court was wrong
these things are
to
different.
repeatedly bless those laws
Than executing
and to
the law.
unanimously uphold the exact same removal provision at issue here in Humphrey's Executor almost a century ago. Reasonable people can and do disagree about first principles, but any abstract theory that would wipe away so much history and precedent should be a non-starter. At a minimum, petitioners would need an airtight theory to justify the radical change that they now seek.
No, we don't.
And
We
they
need
don't
the
have
Constitution.
one.
It's
No
pretty
tool of
clear.
interpretation clearly supports the president's assertion of an unrestricted and indefeasible authority to fire the heads of traditional independent agencies like the Federal Elections Commission and the Nuclear Regulatory Commission. Plus, petitioners' theory cannot be reconciled with their own apparent position on the Federal Reserve and Article I courts.
I agree with that.
Finally, stare decisis militates against
They shouldn't carve out
a century
the Federal
of precedent
Reserve. That
at
should
this
be on the
late
chopping
date.
block, too.
The political branches are more than up to the task of finding reasonable legislative solutions that strike an appropriate balance. That kind of legislative solution is far preferable than abandoning a foundational precedent on which so much of modern governance is based.
All right.
I welcome the court's questions.
Clarence.
Was Humphrey's Executor an executive branch case?
Pithy.
It was an executive branch case, Justice Thomas, insofar as the FTC is an entity that is not operating under the auspices of Articles 1 and 3, but it is also a case in which Congress and the President coming together have determined that it's not part of a traditional executive department.
Could Congress convert all these departments into multi-member commissions? The Commerce, EPA, Department of Homeland Security, Department of State.
And take over.
Convert them all into multi-member commissions and make them removable only for cause.
No, I think, Justice Kavanaugh, that we're looking at 3 buckets here. In one bucket, including the Department of State, you would have departments that under no conceivable circumstance could practicably be converted to a multi-member commission because they are wielding so many of the President's conclusive and preclusive constitutional authorities. But that is a relatively small bucket. Let's say Department of State,
Justice and Defense.
Justice, Defense, Homeland Security, probably.
Are you saying that they're limited by practical concerns or constitutional concerns?
Constitutional concerns, and then practical concerns will come up as well.
Well, let's put aside the practical concerns. I'd like to understand just the answer to Justice Kavanaugh, why tomorrow Congress couldn't transform every cabinet official into a multi-member group. What's the constitutional
and fund
problem
it and say, hey, here's your money, budget, all the things.
Absolutely. And the constitutional problem, in our view, is that Congress cannot limit the President's authority over officers who are wielding the President's conclusive and preclusive conclusive constitutional powers, and that is a line that goes all the way back to Marbury v. Madison. It's a through line through this court's jurisprudence, including Justice Jackson's sentence.
So that applies to the FTC.
has the authority to enter foreign agreements, right?
Oh,
I mean, how do you decide what's conclusive and preclusive?
That guy just
It does not have the authority to enter into foreign agreements on its own, Justice Barrett. The statute expressly provides that the Secretary of State's approval is required before any kind of agreement is executed.
But they could change all that.
The Secretary of State, of course, is subject to the President's plenary removal power.
I just want to make sure I understand, because it's fairly basic. I mean, there's some cabinet departments that you say Congress could just take over. Department of Veterans Affairs, Department of Education, they think, well, experts can do a better job of it. And so we're going to say there is now an agency, the Agency for Education, and it will be run by, whether it's a multi-member group or not. We think it's important for Congress to have greater control over education. So
they can do whatever they want.
We're creating this new agency,
No
and its
separation
authorities
at all.
will be everything that the current Department of Education has, except it will be run by a commission, and they can only be removed for cause. Is that all right?
Yeah, I think that it is probably within the realm of possibility for agencies, yes, Chief Justice Roberts, and the constraint historically has been that these types of determinations have been made through a process of political accommodation between Congress and the President, and over the course of more than 200 years, we have not seen.
Well, but sometimes that accommodation is greater than in other times. I mean, we have situations, let's say, where the Congress, both houses, are controlled by one party, and the President is of the same party, and they may decide that the government would be structured better than by taking over these entities. And so which departments could Congress impose multi-member commission instead of secretary?
Great question.
Yeah, so if you're asking about which ones could be converted today, I think it's probably a pretty small universe in terms of the numbers that could be wholesale transformed as they are currently constituted.
But they could.
Why? Because it appears that the vast majority of executive departments wield at least some powers that this court would deem to be conclusive and preclusive, including under the analysis that this court set out just last term in Trump v. United States, where at pages 620 to 621, the court explained that the President does have a conclusive and preclusive authority with respect to certain criminal investigations and prosecutions, and that informed the court's determination about whether the acting Attorney General was subject to at-will presidential removal. It turns out that the vast majority of these executive departments do have some kind of criminal investigative authority, including armed law enforcement agents authorized to make arrests. Now, that's a significant bucket. You probably have
Every agency in the government today has armed their own police force.
Take 'em
Is
over.
that really
Congress
the
can run
test of
everything.
what's conclusive and preclusive?
So we're not
I mean,
saying
it rhymes, but I don't know what it means.
Justice Gorsuch, I think you're making a good point insofar as you're saying there's insofar as
Platitudes.
Your Honor's point is that there's a
Constitutional
lot of what
platitudes.
these agencies do that would not be deemed conclusive and preclusive, and we absolutely acknowledge that. And
So the answer to the Chief Justice's question is tomorrow we could have the Labor Commission, the Education Commission, the Environmental Commission, rather than Departments of Interior and so forth.
So I don't know that you could do it tomorrow because, like I said, for the vast majority of agencies, there are at least some conclusive.
So it has. What's the percentage then?
So I don't want to pretend, Justice Gorsuch,
I
that
want
I
to
have.
know where the threshold of preclusive and conclusive comes in.
Yes, and so what we would say is that if the
Is it a
agency.
mere scintilla?
I think you would have a separation of powers problem if an agency, even if it's a vast agency wielding a broad panoply of powers, if one of those powers is the President's conclusive and preclusive authority,
What
and
is the FTC?
the officers who are exercising that power are insulated.
So long as one person of the agency is exercising conclusive, whatever that means, that's enough.
So it's enough to have a separation of powers. And I wouldn't just say
This guy's
person,
in
I would say a
trouble, man.
principal officer. It's enough to generate a separation of powers problem. And what is the remedy for that problem, I think, is an analytically more difficult question.
It strikes me, Mr. Agawam, as I listen to this, if you go back to, let's say, the Education Department, which the Chief Justice raised, that the more realistic danger here is that we'll have an Education Department as authorized by Congress, by law, that won't have any employees in it.
Well, yeah.
I think you're absolutely right, Justice Kagan, that there are competing dangers here, and it makes a whole lot of sense to us to weigh the real-world dangers that we know are
That's
a
what
virtual
this is
certainty
about.
that would result from adopting petitioner's constitutional theory, and to contrast those with purely hypothetical risks that have never materialized over the course of American
Public
history. And
policy.
even in the unlikely event that Congress tomorrow was to try to start taking cabinet departments that have been around for a long time and to convert them wholesale into multi-member agencies, which they have never tried to do before. But even if they tried to do that, of course, that would be subject to a presidential.
Well, I think if there's one thing history shows is that we can't anticipate what might happen, and so we might be able to predict what is likely to happen in the very short term, but we don't know. I mean, if we decide this case in your favor now, we don't know what a Congress in 15 or 20 or 30 years might do. We might be able to predict what's likely in the short term. So, I mean, this is going to have longer-term implications.
So absolutely, but let me make 2 points on that. First, there's currently no case that has ever held that Congress cannot give for-cause removal protections to principal officers serving to a single layer of for-cause removal protection for principal officers serving on a multi-member commission. And nevertheless, notwithstanding the absence of any such precedent throughout American history, we have not seen an epidemic of these problems. In fact, we haven't seen this problem materializing at all. But let me make one other point about the real-world danger that is imminent right now that we know will happen.
What?
And that is that if petitioners get their way, everything is on the chopping block. And we're not just talking about the FTC.
Yes.
Opposing counsel said we're not challenging right now the Federal Reserve. We're not challenging Article I courts, but there is absolutely no principled basis for carving those very important institutions out of their rule.
Yes, there is.
You're right that the Solicitor General was pressed quite legitimately about things like the tax court and the claims court, et cetera, et cetera. But I don't know that you can make the argument that the logic of his argument is going to cause these allegedly revolutionary results without being prepared to explain more concretely than you have
stop crying.
the limits of your own argument. I mean, I could go down the list with you of the cabinet officers and ask you whether you think they could be headed by a multi-member commission whose members are not subject to at-will removal by the president. Shall we do that?
Yeah,
How about Veterans Affairs? How about Interior? Labor, EPA, Commerce, Education? What am I missing?
Agriculture.
Mr. Agrawal, are you prepared?
Well, there was a question there.
Yes. So I don't want to pretend to greater certainty than I have about the full gamut of statutory authorities vested in all those other departments. I will say that based on a very quick preliminary analysis, it appeared to us that the vast majority of executive departments wield at least some of the conclusive and preclusive authorities that this court has recognized in the past, including criminal, investigative, and prosecutorial authorities, and also authorities implicating national security and foreign relations. Now, that is not to say, Justice Alito, I think you're absolutely right to say for a lot of those, you could probably take those out, and at that point, there's going to be a fair question about whether Congress and the President acting together could determine at some point that there is a need for a multi-member body of experts to preside over certain government functions. And what I would say is I don't think that you should categorically rule out that possibility as a matter of constitutional law. I can't sit here today and tell you that there's a distinction of constitutional proportions, for example, between the Department of Labor and the National Labor Relations Board.
Well, when you answered Justice Alito about the agencies exercising investigative power, and thus there would be a question whether they could be made independent multi-member commissions, don't a lot of the now independent agencies also exercise that kind of investigative power? At least from my experience, it's very hard to get into the weeds of this particular powers exercised by the FTC and distinguish it from some of the powers exercised by some of the other cabinet agencies that we traditionally think of as executive, or the FCC or the SEC. All of those seem to FERC, NLRB, when you get into them all. So what's your answer to that?
So my answer is the criminal investigative authority is different, and certainly a lot of these agencies have civil investigative authority, including the FTC. As we understand it, this court's precedent just from last term in Trump v. United States, criminal investigations and prosecutions are in a different category, at least as a general matter. And if the logical import of that analysis is that there are certain functions that cannot be wielded even by traditional independent agencies, then so be it. That's the law of the land.
That's right. I understand conclusive and preclusive entirely as we used it. When you're speaking about executive power, can the president control what's done in his departments? I get that. And a criminal prosecution is a good example. I do not understand it as you use it. Why isn't it just as conclusive and preclusive to decide whether to bring charges under the FTCA Act against somebody? Civil versus criminal. It's a conclusive and preclusive decision about enforcement decision of power of the federal government against individuals across the country.
So there's a legal answer and there's an historical answer, and they might blend, Justice Gorsuch. And the legal answer is that we don't have any controlling authority that has ever held that civil enforcement as a categorical matter is the kind of thing that can never be vested in a multi-member agency that enjoys a modicum of insulation from political pressure. And we know that, for example, from this court's unanimous decision in Humphrey's Executor, where you had that kind of civil enforcement taking place, and a unanimous court, including all 4 justices from Myers, said that's okay. And the kind of civil enforcement that was going on there, you had complaints complaints being issued. You had cease and desist orders.
Cease and desist orders, but not lawsuits in court. They had to go to court. And I'm just curious, though, fine, I accept your point. It's a good point about Humphreys. But why isn't that conclusive and preclusive decision whether to use the federal government's full power in a prosecution where you can seek fines and incur all of the penalties that are associated with violating the FTC Act?
So I think part of the answer is historical and part of the answer is functional. And on the historical part, we have had all kinds of civil enforcement of federal statutes taking place, including just private statutes that authorize private attorney generals, as this court has recognized in many, many cases. So you have a long, long history and tradition of private actors wielding, kind of enforcing civilly federal statutes. Now, I take the point that civil enforcement on behalf of the government of the United States.
That's not the executive power, but criminal actions is the executive.
Yeah, I would not say.
That's what you're asking us to.
No, I would not put it that way. I would not say it's not executive. And in fact, in CLA
law. So it
law,
is executive?
Yeah, in CLA law, this court said it's not only executive, it's quintessentially executive. And that's okay, because agencies like the FTC also engage in adjudicative activities, and that would be deemed quintessentially judicial. And nevertheless, they're not subject to plenary removal on the part of the judiciary. They engage in rulemaking that could be considered quintessentially legislative, and nevertheless, they're not subject to plenary control on the part of the legislature. The issue is not whether it's executive in some sense. The issue is whether it's constitutionally committed to the president's sole and exclusive discretion. And as a matter of history and precedent, we haven't gotten there yet.
So even some quintessentially executive functions, in your view, are not vested in the President of the United States?
Yes, I would say they're not.
You have to say yes to that.
Yeah,
based on what you've just given
They're not
us.
constitutionally committed to the person of the president and to his sole and exclusive discretion.
Didn't we suggest as much in Humphreys? I mean,
all right, so that's our exit cue. Ketanji now weighing in. I don't understand anything. Of course you don't. So I think that this is going to be a big decision in favor of the Trump administration. From what we heard today, probably something like 6-3. I don't see any reason why Comey or Roberts would not join in on the conservative wing. So big day out of SCOTUS. Of course, we'll wait for the decision to come down.